Alrighty, and I think that's just ticked over to midday. Good afternoon, everyone. Welcome to this LinkedIn live chat with me. I'm Alice Rue from SMB Advisory, and I'm here today with the wonderful Mark Smith of SLF Lawyers. Hi, Mark.
Hello, Alice. How are you today?
I'm very well, thank you. I'd like to begin today by acknowledging the traditional owners of the land upon which I live and work, the Yuggera and Turrbal people, and pay my respects to elders past and present, and extend that respect to all Aboriginal and Torres Strait Islanders here on the call today. Thank you, everyone, for joining us today in LinkedIn Live Land. We are also recording, and this will be available shortly after we finish up on the SMB-TV YouTube channel. There's been a bit in the news recently about individuals being declared vexatious litigants, and it's always been of interest to me as to where the line is drawn and what thresholds need to be met before an application can be made to have someone declared as a vexatious litigant. Now, Mark, I know you have some experience in this area, and I feel really blessed to have you on this call today to take the opportunity to pick your brain about all things vexatious litigants.
Yeah. Thanks.
That's fine. I want to remind everyone that you can put any comments or queries you have in the chat, and if we can, we'll try and discuss that through the course of our chat. Otherwise, we will take queries on advisement and come back in due course. But Mark, we might kick off by learning a little bit about you. Do you want to give us the Mark Smith elevator pitch?
Sure. No worries. It's not very long. It's pretty dull, but basically, I'm a senior partner here at SLF Lawyers, a firm that's now about 90 staff, 40-odd lawyers, Brisbane, Sydney, Melbourne, and as of yesterday, we opened on the Gold Coast.
Oh, congratulations.
We've got 3 of our lawyers going in. So our existing staff have chosen to move there, and we've got an existing client base there, and we're looking forward to seeing that we're growing an East Coast presence. The firm SLF, the forerunner of SLF was MSB, started in 2006 in Brisbane. It's grown from small, humble beginnings to a fully serviced legal operation that basically does all types of legal work, probably apart from mergers and acquisitions, IP law, and we don't do a lot of crim, but we've got estates, we've got family law, we've got employment law, 3 new areas, along with also our key areas of commercial litigation, debt recovery, and also your favourite area, insolvency. So it's certainly a bigger firm, and there's also a large element that we're doing some insurance, motor property damage recovery work. So it's got lots of arms and legs to it now, and it's grown a lot in the last 12 months.
Lots of different facets, and I guess that's one of the good things about having a firm that works in so many different areas is you get to look at a lot of these different issues that sort of can bookend into each other depending on the nature of the work.
Very much so, and it's something. The word vexatious comes up a fair bit between practitioners, and the terminology of being a vexatious litigant. You hear it a lot, but it's something that certainly, from a threshold point of view, which is we were speaking earlier, is something that's a very high bar to jump over. And there's a difference between the rough and tumble of and pressure of litigation as opposed to being termed a vexatious litigant or being vexatious in your dealings with somebody else. And that's really a key element that is the key element to the terminology and being ordered as a vexatious litigant. So that's the basis of
it.
And the fascinating thing that clashes with the legal side of it is the personality side of vexatious litigants. Going forward on that point, it's very easy to look at this. The Queensland Supreme Court websites, the Justice website talks about there's only 27 registered offenders called vexatious litigants in Queensland. Now, the interesting fact about that is 24 of them are male.
So is that right?
Yes, so that's since 1983. There's been 2 added in the last year.
Okay.
And the last matter was with Supreme Court Justice Sofronoff. We had a chap by the name of Ross Bradley who opposed that he had an unlicensed drinking charge, so he took it all the way to the Court of Appeal, which was probably not a public interest, and he appealed on the basis that that the sovereign rights of himself did not recognise the court. And Sopronov said, "It's strange if you don't recognise the court. How come you're here?"
That's interesting, isn't it? Yeah.
Yeah. So he was cleaned out, washed out, and put down as the 20. He was number 27 on the list, but quite a ridiculous viewpoint, and it made a lot of news in our Proctor, and it's worth reading the Sopronov judgment on it. He puts him in his place very quickly, and
I guess you'd have to, wouldn't you?
These
probably. Yeah. I was just going to say the very nature of it. If we step back right to the start, do you want to maybe just look at talking us through what, for people who don't know, what a vexatious litigant is, what the sort of definition is? And there's an act in Queensland, isn't there? An actual vexatious.
There is, and there's two things to it. There's a 2005 legislation that created statute around how you deal with a vexatious litigant. And the second part to that is there's actually a practice direction from 2010. Just talks about the actual steps taken and the notices to be provided and the orders that can be granted in such a situation. But really, a vexatious litigant's on three parts. One being an abusive process of court or tribunal. Doesn't have to be a court. It can start in QCAT. And the matter that I got all the way to the Supreme Court originated in QCAT in 2009. The second one is if you harass or annoy, you cause delay, detriment, or wrongful purpose. And thirdly, without fair or reasonable grounds. They all meld into one, but abusive process can be that you don't have fair grounds to appeal or to sue somebody, and you're just constant with it. And going back a step, you have these people, and SLF Lawyers 2 years ago went through an in-service, a CPD, on what they call a querulant. Predominantly people who have been termed vexatious, that there is a bit of a social profiling to them. And one of them is really, it's usually a male over the ages of 40 to 70. It's not a female. It's someone who's also suffered a large loss, that they've lost their fortune, or they think they've been wronged, or that there's some type of legal effect that's caused them. They usually don't have any money, so they've got nothing to lose. And these people are constantly hammering on about one point of law, about one thing, and it goes on and on and on. And they'll usually talk about the sovereign rights of themselves, the United Nations, the Charter of Human Rights. Those things come through as a very clear strain of work, and it's written many times. And you'll also see when they do file a lot of material, it may be 400 or 500 pages long, and it may be just a total repetitive nature.
Same thing,
same thing, and it just comes in a different form. And they know enough to look like it's quite good. Now, remember, registrars can actually make an order or seek to make an order of a vexatious litigant. The thing with registrars is that if you've got registrar staff, registry staff, they're accepting stuff, and their role is really to accept documents coming in. And remember that the role of court is not to, at that point, to be judge, jury, and executioner. It's to accept documents for what they are, and for the determination of a court, and for a judge or jury to determine if there's a cause of action or there's a right or wrong to be heard or had.
Absolutely. So that's really interesting. And registrars likely to do that, because obviously, sort of in a lot of, obviously different experiences that I've had, if you've got quite sort of sticky actions that do come about, whilst they can make certain determinations, they're not as likely to. Would that be a fair assumption?
That's a fair assumption. I'd say they'd pass it up the chain because they probably don't think they've got the authority to do so, and it's a niche area, and it's something that they probably think, well, it's not their pay grade to make that decision. So that's something that's interesting. The Attorney General of Queensland can also, particularly there's another element to vexatious litigants. They do petition to state law, federal law, or local law about, could be guttering, it could be some wrong that they think they've got, and it goes back to that querulant, where this is wrong, the koalas have got to be saved. That's probably not a good example, but they bang on about something. So the Attorney General has that right as well to to say, make an order to censure them, to say you can't raise this any further or whatnot. So,
Okay.
but again, that threshold's very high.
Absolutely. And so it can come from a number of different angles then, is what you're saying, is, you know, depending on where the, and it has to be more than annoyance. I want to say where the annoyance, but where that sort of vexatious nature comes in, if it's in a sort of complainant situation or if it's actually in that court-based situation.
Very much so. It's got to be, and that's where the threshold is so high. And there's a good case in New South Wales called Markham that was handed down not too long ago. It's not a Queensland matter, but it draws on that, and it's another part to the vexatious litigant. It was to do with a GBH charge. There was a criminal charge where a man was jailed who was represented by a solicitor and a barrister. And be aware that the vexatious litigants on the list are all people who are self-represented. They're represented by parties, because the cost would be what they're doing would be exorbitant. Plus, also, lawyers have a duty to the court first before their client to say you can't run this rubbish, and you can't go ahead with it. So lawyers are usually not seen, but initially they may be involved in the first proceeding. And the case of Markham was where there was an imprisonment of a GBH charge that was found guilty by a jury and imprisoned. During his time in jail, this chap who was in his 50s decided to raise that he'd suffered loss and damage, so he sent an invoice to his barrister, which directly for $500,000. And the issue with that is, firstly, you got to have a proven, where's his loss and damage from losing a criminal case. But secondly, there's no direct relationship between barrister and client. It's via they've got a general common law immunity to be held against any client who sues them. And secondly, they've got a solicitor takes those instructions. And in that case, the solicitor had a common law immunity as well. So he goes about and sends the demand. The demand's not answered. So he decides to go off and sue his barrister and also his solicitor for this $500,000, which is, and he loses, and then he appeals and he loses, and he even to the point where the barrister involved the New South Wales Bar Association to represent him or to be involved as a party, because he wanted them to be re-educated as well. So that's why he joined them as well. So the vexatious litigant can go pretty wide. He'll join parties and whatnot, and it can be pretty.
Yeah, wow. So now that probably leads me to my next point. And the thing that probably most recently got me interested in this matter was the Salim Mahaja case that's been sort of around, and he's now been declared a vexatious litigant by, I think, a New South Wales court. Yep. And it obviously takes a bit to have someone declared a vexatious litigant. So what are the steps? Where do you start? So if you had somebody who, as you were just talking then in that case, you start with a demand and there was nothing, it was always going to be an abusive process. At what point do you need to get to for one side or the other to raise that we think that there's a vexatious element here?
Well, it's usually I think the first point that they lose at first instance, or they don't get what they want, and also it doesn't have to be more than one matter. It can be the same matter, a constant appealing of it. So, a good example, we had a matter before the Supreme Court, before Justice Byrne in 2018, that started in 2009 over a series of matters where we acted for a private person who was selling a property, and he was sued in QCAT by a real estate agent who sought his commission because he said he was the effective cause of sale. This was before our involvement, and what occurred then was our client said, "Oh well, it may be better for the balance of probabilities. I'll settle this out of court. I'll pay him some money, and the matter's gone." So with QCAT, he was represented at the time, our client, by another law firm. The matter settled for a good amount of money, $20,000 in commission, and our chap thought it was at the end of the matter. The respondent who obtained the money thought this was great. This was an easy way to make $1. I'll try to make some more money out of our client. So we actually then sent a demand to our client, who became our client at that point, saying there's an additional amount of money owed to me. You owe me more money. So he went back to QCAT, and we were able to be represented. We sought leave to be represented, and the matter was dismissed without costs. So he had to go on QCAT, which generally, as you may know, and our listeners and viewers may know, that QCAT's is generally a no-cost jurisdiction. You can be represented, but the QCAT tribunal usually tends not to award costs. So in some ways, this applicant, he was applicant at the time. He had a free hit, so he didn't go so well on that, and he didn't lose costs. So he thought, oh well, that didn't work. I'll have another go. And this chap's in his 60s, and discovered lately that he had lost all his money through real estate. He was living in a rental house. He had nothing, but apart from probably $20,000 from our client. So this started in 2009. So and I've got the notes here, come 2012, that was the first order. So he was living up the coast, and the property was the sale property was at the back of Noosa, I forget the name of the lake there, but that's where it was. It was it was a good property. So he decided to shift his attention to a court. So he went to the Maroochydore Magistrates Court, and he went again and said, I'm still owed this money, but he sued in his personal name, not his real estate company, which at the time I believe was now deregistered. So so you can see there's a common law, common theme here. There's no money. So it went through to so we got sued again, and we sort of strike out in respect to the action, and we provided all the QCAT, what would have been thrown out of QCAT, with no costs. And this time we were successful with costs in the Magistrates Court, about $6,000 in costs. And why I'm mentioning the figures is because it becomes a little bit important a little bit later. Yeah. So then he thought, oh well, I've lost that one, so $6,000. Our client's still in the position of one. I've got rid of him. He owes me some costs. I'll ask for costs. He'll go away. This is the third time he's done this. Anyway, so we've won. So he's won. So anyway, so he's had a loss in the Maroochydore Court. So he then goes to the Gold Coast Southport Magistrates Court, because he'd moved down there for 6 months with his wife. So he then elected to try the same thing down there, and again he sued, and he kept it away. But in the meantime, we had our costs assessed and demanded the costs be paid. It was over the threshold of bankruptcy. So we've asked for costs, and he, in the 28 days, decides to appeal the decision of the Maroochydore Magistrates Court. So it goes to the Maroochydore District Court. So
this is at the same time as he's running Southport.
Correct. So he's got an abusive process already. He's got a matter down there. He's had 2 matters in QCAT. He's got a matter in the Mags Court now. He's appealed to the District Court. Wow. So again, it's been thrown out, and there's been a cost order against him in the this is now 2013. It's 4 years on. So he's lost on that, and then there's a second amount of cost to be paid. So those costs are assessed again, and we ask him for further costs. This time, my client's had, to an extent that he continues to go, and our suggestion was you should recover your costs. If he can't recover your costs, if you won't pay them, you might seek to order a bankruptcy notice, proceed with a bankruptcy notice, see if he pays on that. If not, we might then file a creditor's petition and see where it goes. That's what occurs. He doesn't pay on the bankruptcy notice, and in the meantime, he goes now to saying that we're fraudulent. So he makes a police complaint against us, which is thrown out. He also goes to the Legal Services Commission, where for anyone listening as a lawyer, it was probably the best solution I ever had with the Legal Services Commission. They rang me up and said, someone's just complained about you. We're throwing it out now. Goodbye. They hung up.
Oh, that was it.
Yeah, that was it. So we now get to a point where we're going to, we've got a creditor's petition on foot. The district court matter's been thrown out. We then go to court. He hobbles in court with, I think he's in a wheelchair, and says, he seeks a couple of matters where adjournments, but eventually he can't pay. We're awarded petitioning creditors' costs, our audit costs and whatnot. So he's bankrupt, and generally, when you're bankrupt, you have a lot less standing legally before the court. But this is where the registry may need to consider these things more. They take things on face value. So he then appeals to the Supreme Court of Queensland, files in the Supreme Court of Queensland after a police appeal, after legal services. And we've had a number of runarounds, and we end up in court where we counterclaim with a vexatious litigation application. And on the day, and it's probably the day that I've been in court more people have rung me after court saying, "How'd you go?"
Yeah.
We got him outside, and he said, I said, "Do you want to go on, or do you want to, maybe termed a vexatious litigant today, or do you want to just give an undertaking that you'll go away and never sue us again?" And he actually wrote and handed up an undertaking to Justice Byrne and said, "I'll undertake never to sue again." So we fell short of that 26th or 27th number of vexatious litigant, but we got to the point where we haven't heard from him ever again. Our client still owed costs for a long, probably a 7-year journey. But the threshold, as you can see, the summary of it was there were 6 applications on foot. And and again, Alice, my response was that there was a big call over that day. There was probably 8 or 10 barristers in the room that I knew. I reckon at least 6 rang me that afternoon and said, what happened? Because, as you said, there's so much interest in it. And just reviewing my notes on the matter today, it's certainly something that's of great interest. We use counsel on it. It's I shouldn't say it's a great little act. It's a very easy act to use under the practice direction. So, but the unfortunate thing for any client is it may
cost a lot of money.
Cost a lot of money, a lot of stress involved. And that's where that is. And there's also the passage of time. It's continual. Yes. So currently, we probably see the word vexatious a lot. The width of our firm is quite big. We do occasionally get people who feel aggrieved, think that there's something wrong, and they'll play with the United Nations and stuff like that. So it's certainly something that's of note. But the matter itself is, it is, as you say, fascinating that we can get to that. And the other thing about it is, if anyone who is watching, they can go onto the court site and you can actually look at those names.
You get the list up.
The list is there. The list is there because I think and we actually had someone approach us a couple of years ago to act for them, and they found us via the net. And he says, "I'm a vexatious litigant," and I didn't really think much of it at the time, and we didn't act for him further. And he is. He's a he's been. He can't let go, and he's a man in his 60s. He's living in Bali. I'd say because he hasn't got a lot of money to live in Australia, and I'm making a judgment call on that. But there's certainly very much like a social profile.
There's a profile, isn't that interesting?
Very much so. Yeah.
And tell me though, if someone's been declared vexatious, is that it totally for them? Like, it's not just in terms of the one proceeding, or is it is it across jurisdictions? Is it across proceedings, or is it sort of just in one sort of narrow line?
Well, the Vexatious Litigants Act is a Queensland-based act, so it deals with courts in Queensland. Yeah. So some of the orders
gone down to Tweed and started again.
So they could go again, and we were worried that he'd go over the border and do something, and they take it on face value, and they probably couldn't not reject the case. But some matters are. One of the vexatious litigants in the list there talks about the Brisbane City Council. It kept suing the City Council, which is all to do with that, petitioning to public authorities about, we'll go back to the koalas. You've got to save the koalas or something. They keep going, and they had to shut them down. But that litigant can only not go against the Brisbane City Council, and this is where these querulants get a bee in their bonnet, and they can only see one thing. And they're determined for justice on some wrong that they think's happened. And I was mentioning to the staff this morning here, we had a matter where a chap came to act. He had a judgment that was 11 years and 50 weeks old. He wanted us to act within 2 weeks of getting it. He'd hung on to this matter, and it had burned him up for 10, 12 years, and he'd lost a fortune. It was doing with a hotel in Rockhampton. He could even quote me how many kegs of beer there was when he lost. There was a contractual dispute. He lost it. Someone else, and he believes he was wrong, but he hung on for 12 years and he thought, I better act on it finally. And it was too late to do anything. He didn't took no action. But again, he was a chap who'd lost his fortune. He was again in his 60s or 70s, so it can be very specific. So it can't be as broad. I think that from a justice point of view,
from a civil liberties point of view, you can't.
Yeah, a private citizen. Yeah, it's only the person who's aggrieved. So, in our case, it was a person selling a house, and the undertaking was only against our client. There's nothing wider than that, because he should remain. He should be able to remain his rights. You can't not sue. Cool. But yes. So
has there anyone on that list that's been declared vexatious twice? Like, is there a sort of a status once you're on there, and if you find out that there's another, path that they want to go down, someone else that they want to complain, does it help the other side in that second proceeding if that person is vexatious in another proceeding?
I think you know what you're up against then, Alice. Also, that you can't say go away, you're vexatious. I think you know what you're in for a long haul, and they may be self-represented, and they may do it the long way, and they may be serving. They're also the types that will serve you at 5 to 5 on a Friday afternoon with 2 or 3 reams of paper, which may be the repeat of the same. And the court previously. And I think we've got one in our midst as we speak in our firm. So watch this space, so we could come back.
We might have a bit more to talk about.
Back. Yeah. So
totally without notice. I'm sorry, this question from me, but it's interesting as well in terms of looking at security for costs. Your client you're talking about in that earlier matter, obviously over many years, and they would have had a lot of their own legal costs, let alone the costs that were awarded to them, that the litigant other side didn't pay. Is there at any point during that where you can seek a security for costs, and does that shut anything down, or how does that work?
Well, under the matter that we've got, we did seek security of costs. And when we went to the court for application to hear the matter, our man who was suing us chose not to turn up. So it still didn't stop the matter. He just kept going. Remember, he's a bankrupt by the end of it, and he's still suing us. So we did get a security of cost application. We got cost on that too. So it's hard to get a bit of a snowball effect. Every time we won, we got more costs. But
it doesn't help if he's not going to pay.
Didn't help. It didn't help. And it was allegations of fraud, allegations of me being a bad guy, bad lawyer, and all that stuff. But it was very much so that we did seek security of costs. It was an obvious for a fellow who was bankrupt, but the courts didn't say, "Oh, you can't." Not that they won't make the decision yet. We have to make the order. So we have to make the application. But very much so.
No, and I think that's part of the headache, isn't it, in terms of this? And you can't begrudge anybody for having their legal right to start things, but it's when there's that abusive process where there's no basis for an action, and then there's costs that are accruing on both sides. I think it's quite problematic. So that's really interesting. So the vexatious litigant status is only in regard to that proceeding that's been brought, but as you were saying, there's that profile, isn't there, that sits where there seems to be sort of quite a tunnel vision on that one proceeding. So, we haven't seen too many that have gone again to be declared in other proceedings.
Correct. And we've looked through and back in our matter, which was to do with a real estate agent, he had sued in the 80s in Victoria at least 10 times and money for his fees. So he had history, but no one had gone any further because they're all small matters. But maybe he had some wins down there and he thought this was a good way to make a dollar. I don't know, but it was certainly 40 years ago. But going back to the tunnel vision, it speaks for itself. 24 out of the 27 are male. So it's to do with a male who's lost his way, or he's he's probably got some certain outliers of personality that are quite strange. He may have lost his wife or divorced, but I think a lot of them are supported by a partner. It's just an interesting thing. So when you see it coming, you're more worried. You're not worried, but you can see what the type of person's coming at you. It's got nothing to do with the law. It's got to do with everything to do with they think they're wronged and they've got to be right. And I find it fascinating that they can live their life. They must spend so much of their time doing this, that they haven't got much time in the rest of the day to do anything else, let alone
Well,
work.
I've seen a few matters as well, really tragically, where there's been, and it hasn't necessarily got to this part. I've seen it in bankruptcy and family law situations in particular, and it has gone on for so long that it just seems that is the life's mission of the person, is to be in that proceeding, and they don't want to settle it because I think there's a lack of purpose once it's done, and that's really hard for all parties, I would think.
But don't you think a bankrupt will talk about everything before he's bankrupted? He'll talk about everything, every excuse under the sun why he can't pay, but he won't talk about one thing: the debt owed. He won't talk. He's got all these things that have wronged, and I think there's a real correlation between that and vexatiousness. It's in that same field, and they won't mention. They will not mention. Oh, there's no commerciality to it. They'll blame everyone and what happened and so I think you're exactly right, Alice.
Yeah, and I think in this world of sort of being aware of more vulnerable clients as well, I think it can work a number of different ways. I think the institutions, the courts, etc., are more likely to give indulgences, especially when they think that there are, certain vulnerabilities, and we need to look at that as well. Are there any instances where like I know that for us at the moment we're going through a matter with a self-represented, and it has been a number of matters over and over again. We've been really blessed, to be honest, that they've now been awarded actually an SC to work on their behalf pro bono, and it helps everything get along a little bit. Is there options for that, and also are the litigants likely to listen or likely to take that up in these sorts of situations?
The short answer is I don't know, but my assumption is that these people wouldn't be able to obtain legal aid because they're private persons looking for a civil wrong. They're not criminal matters. Although some matters might hinge on criminality, it's more as in the matter of Markham. He wanted to sue his barrister for prison, so it's the wrong person. But I haven't seen any in that regard, Alice.
Excellent. Yeah. No, it's good to know. And I just think because sometimes it's helpful, and especially in an insolvency situation, almost have an intermediary. But there's a lot of times when the other side's not ready to accept that yet as well. And that makes it, difficult on everyone's part. Okay, so I think we've gone through most things. Did you have any other final key points that you wanted us to take away on all things vexatious litigants? So you've taught me a lot today, Mark.
No, I'm just the thing that I take out of it is the human element, and we've got the law there for lots of reasons, and I guess the act's very, very fine. You've got to add colour to the act. There's not many steps in there, but in litigation, particularly, we have a large number of. We do see some people. There's some people we seem to sue a lot, and they'll have the same reason why they can't pay, and it's about money, and it's every other reason bar the debt itself. And I think there's a real element, and I think the indulgence there for people who are self-represented is very clear about mental health and mental health awareness, that people won't brush them aside because of that, because I don't think they want to be seen as a cause of any further angst. So that does create for our client and call him a good guy, call him whatever you want, but the person who's getting attacked has to go a long way before they get to that threshold, which is unfortunate. And it can be very stressful for people, litigation, particularly when you're in the gun and your world stops. So these people don't see it that way. They just think that they're wronged, and I don't think there's some issues there with their mental health.
Yeah, no, absolutely. Look, thank you so much, Mark, for your time today. I found all that's really super interesting. And we're lucky to have someone with your experience to talk us through it all. Now, just before we go, where can our audience find you if they want to get in touch?
Oh, certainly. Just Mark Smith, partner at SLF Lawyers on the screen there. We're in George Street in Brisbane. We're in Bundle Road on the Gold Coast. We're in Hunter Street in Sydney, and we're on Collins Street in Melbourne. Again, by all means, anyone who's got a question or it is a really fascinating topic. Litigation can take on its own life, but this stuff is next level. So
Absolutely.
we're around. So by all means, if anyone wants to reach out and speak to me about anything that we've spoken about today, more than happy to take their call.
Yeah, excellent. And I'll just point out that both Mark and I are very pro koala, so I don't think, just in case anybody was curious.
No koalas were hurting the production of this
Correct.
show.
No, absolutely. Excellent. Thanks, Mark, and thanks everyone for watching this afternoon. Have a great day, and we'll see you soon. Cheers.
Thanks, Alice. See you.